Hello everyone, my name is Teresa Lewis and I'm the Director of the Office of Small and Disadvantaged Business Utilization at the U.S. Department of Health and Human Services. Thank you for joining us today for our monthly acquisition training program. Today we have with us an expert in small business, a friend of mine, and someone from SBA who truly knows the regulations inside and out, the laws and regulations as they impact small business. And I'm excited that he's here. Ken Dott. Ken, thank you for being here as always.
Thank you.
Once a year, we ask Ken to come over and update everyone on what's new in the small business regulations. What are the new legislation updates? There have been some revisions to limitations on subcontracting. There's been some changes on in the size area, the non-manufacturers rules. So Ken is going to share with all of us. I'm glad you're here, Ken. And at the end, I will come back and then help you with the Q&A. All right?
Sounds good.
As always, thank you
very much. Thank you. Appreciate it.
All right.
All right. So since I last spoke to you all, there's always new laws that come out and new rules that SBA does and that come out. So I'm going to update you on some of the things that we've been doing and try to update you on changes that are coming both in SBA's regs and in the FAR. The first major change that we did was on the limitations on subcontracting, and we finalized our rule, and this comes from the Defense Authorization Act of 2013, and it changes the way we subcontract in two primary ways. First, it changes the calculation. For example, for services, it's labor cost incurred for personnel, whereas under this, it's amount paid. So it simplifies the calculation, and then it allows small business prime contractors to rely on similarly situated subcontractors to help them meet the limitations on subcontracting. So part of this is in SBA's rule. It's final. I give you the citation there. Your first question will probably be, can we use this now? And the answer really is no, because we haven't updated the FAR. This is a provision that has to get into the FAR clauses that go in solicitations that get into contracts. And so until that's done, most CEOs will just follow what the FAR says. They're going to put the old clauses in there like 52-219-14 and so forth. Now you can, under a HUBZone set aside or SDVO set aside, rely on similarly situated entities already. That's a policy choice we made a long time ago. So we finalized this rule. There is a FAR case open. We'll have to see. I cannot predict when that'll finally actually get into the FAR. Some of the specifics, though, around this, what do we mean by similarly situated entity? And it depends on the type of contract you're performing. So if it's a HUBZone set aside, obviously the prime has to be a HUBZone, and also the subcontractor would have to be a HUBZone small business concern in order to count towards the limitations on subcontracting. And the same rules will apply to SDVO, women-owned, and so forth. You have to match what the eligibility of the prime will dictate what the subcontractor has to have. We were asked to clarify size, and size is a little different because in contracting we can have a size standard assigned to a prime contract and a different size standard that is assigned to a subcontract, because different types of work has different types of descriptions. And so a big kind of contract could have all kinds of services and supplies underneath it as subcontracts. And at the large business subcontracting plan level, we tell the prime to assign different size standards and NAICS codes to their subcontracts. And so we want that to also happen for this. So that means that the size standard could be $17 million for the prime contract, but there could be a service under there that has a $35 million size standard. That's fine, as long as the small business or the business qualifies as small for that size standard. They'll be able to count towards similarly situated. The percentages are very similar to what we've already known. For example, for services, it's 50%. But you'll notice nothing is excluded. There's no discussion of materials or anything. I'll talk about mixed contracts later, but it's basically, if this contract is for services, 50% of that needs to be retained by small businesses, either at the prime or sub level, basically. The other 50% could be subcontracted. You'll notice also for supplies, it's 50%, but here we exclude the cost of materials and not considered to be subcontracted. So that's for a manufacturing or a supply contract. Percentages for general construction is the same. It's 15% has to be retained, 85% can be subcontracted, and also the cost of materials are excluded from this. And then specialty trade, it's the same thing. The prime and its similarly situated subs have to do 25%, 75% can be subcontracted, and of course the cost of materials are excluded and not considered to be subcontracted. I mentioned mixed contracts, and so this is where it gets a little confusing with services, but we want the small businesses to do the service portion. So if it's primarily for services, they can subcontract 50% of the services to another than small concern, as long as 50% is retained by small businesses, but any supplies under that would not be considered as part of subcontracting, because we don't usually expect service providers to also manufacture things. And we don't expect manufacturers to necessarily do services. So whatever the primary purpose of the contract is, that's the rule that applies, and it applies to that primary purpose. So if it's services, it applies to the services portion. Oh, jumped too far there. So when we talk about this, we want to make sure that the whole purpose of the limitations on subcontracting is that we don't want to have pass-throughs. We don't want to award things under set-asides to small businesses and then have them turn around and give it all to a large business, because then there's really no purpose to having our programs. So we're also going to make sure that under this rule that when you do subcontract and you want to use a similarly situated entity, only the work that they actually perform will count. If they turn around and subcontract, that will not count towards the performance requirement. We get asked a lot about how do we determine compliance? What's the measure? And what we've said in this rule is that we want it to apply, this limitation applies to each term of the contract. So on your typical one-year contract with 4 one-year options, we want the small business to be in compliance in each year of that contract. We'd had situations in the past where a small business said, well, I'm only going to do 10% in the first few years, but I'll do 90% at the end. And then, of course, sometimes they would not do that. And so that kind of defeats the purpose of this as well. So the compliance is each term. So that means on an IDIQ contract, for example, it's the term of the contract. So they may be below it on one task order, but they may make it up on another one, so that at least during that term, collectively under all their orders, they're meeting the limitations on subcontracting. But we do give contracting officers the discretion, if they want, to require compliance on an order-by-order basis if they feel that's easier. Some agencies wanted us to do it that way, others wanted to do it during the base term, so we give contracting officers maximum flexibility in terms of compliance. As a contractor, you're going to have to read the solicitation and make sure you know what the rules are. We also clarified that when we talk about performance, we're talking about performance by employees of the concern. Right now, if you look at what 52.219.14 says, it talks about employees of the concern and cost incurred for personnel. It does not include independent contractors, and so that's what we've clarified here. This may come as a surprise to some firms out there that have been operating as if independent contractors were employees, but they're really not. If you're telling the IRS that an individual is an independent contractor, you're telling them they're not the employee. It's kind of one or the other. You can't claim one as an employee for one purpose and not for another. While we were fixing or implementing this limitations on subcontracting rule, we also took a look at the joint venture rules and made them easier. So basically, 2 firms can joint venture and be considered small, at least as long as each entity is small under the size standard. Previously, we would generally combine them, and so collectively they'd have to be small when you added them up. So what this means is if there's a $20 million size standard on a solicitation, a small business with $19 million in revenue can joint venture with another small business with $19 million in revenue and be considered small for that government contract. We clarified some stuff around affiliation. You should just, for general knowledge, SBA makes size determinations, but we consider parents and children to be affiliated. There's a presumption that if 2 parents or children own 2 different concerns, that they're affiliated. They can rebut that by showing that they don't do business together and they're not in the same line of business, they don't share things. We also had some clarification around economic dependence. There's a presumption that if 70% or more of your revenue comes from another concern over the previous 3 fiscal years, that you're affiliated. But of course, that it can also be rebutted by showing, for example, that you're haven't been in business for 3 years, that you're a startup. Obviously, your first contract is going to be 100% of your revenue. So this applies when a firm has been in business for a long time and solely does business with one other concern. We did some clarifications around when we determine size. Obviously, it's generally at the time of offer, including price, but in some specialized scenarios, we don't get price, but we will determine size at the time of the offer for these type of contracts. We did a clarification around recertification. Basically, if you submit an offer and you're acquired prior to being awarded the contract, there's a requirement to recertify, and basically you're still eligible for award, but the agency won't get credit for the award as an award to a small business. We did a lot around clarifying the non-manufacturer rule. This applies to supply contracts only. We clarified, for example, that a rental, we consider that to be a service. We don't consider that to be a supply contract, and therefore the limitations on subcontracting that apply to services and the non-manufacturer rule do not apply. We've made it clear that when we waive the non-manufacturer rule, that doesn't necessarily waive other legal requirements like the Buy American Act or the Trade Agreements Act. Those are different laws that the CO is responsible for. All we're waiving is the requirement to supply the product of a small business. That's what a waiver is. We've clarified for multiple item acquisitions. If 50% of more of the items are made by small businesses, you don't need a waiver because you're meeting the general principle is that we want 50% or more to be made by small businesses. So in that case, you don't need a waiver just because one item may be made by a large business. On the other hand, if 50% or more of the items are made by large businesses, that's when you need to request a waiver from the Small Business Administration. You come to us and you say, for a contract-specific waiver, that here are the items I'm buying and here's the manufacturer. They're not made by small businesses. And then we take that and verify it, and then we can issue you a waiver of the non-manufacturer rule. We generally want to do this before the solicitation is issued because we want everyone to know what the rules are. On a typical supply contract, if you submit an offer as a small business, you're telling the government that you either made the product or you're supplying the product of a small business. Only if there's a waiver are you allowed to supply the product of a large business on a set-aside contract. So we want it done before the solicitation is issued, or if you've already issued it, but you come to us, as long as you give people time to respond, we might consider issuing the waiver. And then, of course, we want you to provide notice in the solicitation that there is a waiver. We also sometimes do it after contract award, where you've already come to us for a waiver for many items and you're adding some items and it's within scope. We will do a waiver for you after contract award in that limited circumstance. Again, I mentioned we want to make sure everyone's on notice of what the rules are, so that notification needs to be in the solicitation, and you need to give firms a reasonable time to respond if you amend your solicitation to include the waiver. We clarified finally how we're going to deal with software. Generally speaking, if you hire a company to create software for you, that's considered a service. That's IT services. But if you're buying software off the shelf, kind of like a commodity, a lot of agencies and industry treat that as a supply. So we're agreeing to do waivers of the non-manufacturer rule for software in certain circumstances. Basically, it has to be in a almost like commercial software sold to the public in substantial quantities and is being offered without modification. You're literally buying software out of a box. If there's a bunch of add-on services where you're buying software made by a large business, and that large business is also going to provide 24-hour support or customization and things like that, that's a service, and that's not something that we're going to waive. We can only waive the non-manufacturer rule for supply, and it has to be like a commodity. So we will not waive it if the value of the services is more important than the supply portion of it. We also clarify that certain services we don't consider to be a supply, like hosting, subscription services, and things like that. So we don't do waivers for that. We also clarified in this rule that's final that the limitations on subcontracting and the non-manufacturer rule do not apply to small business set-asides below $150,000. I think the idea, and this goes back, this is really how it was written before the NDAA of 2013, and it certainly is after. I think the idea is these are simplified acquisitions that are reserved for small business, and we don't need to worry about, for these small purchases, limitations on subcontracting or getting waivers. It applies to small business set-asides. If it's an 8A set-aside, HUBZone set-aside, women-owned set-aside, or SDVO set-aside below 150, all those rules do apply. So it's strictly, literally, small business set-asides below 150. We also did a little bit of clarification in this rule around the 8A program. For construction, we consider construction usually as new. If you're creating a building or building a bridge, that's considered to be a new requirement. However, we do, in certain circumstances, think that an IDIQ type contract for recurring services, for example, doing roofing at a base over 5 years, when that comes back up for recompetition, we consider that to be not new, but recurring. And the reason that's important is because we have the rule for the 8A program that says once 8A, always 8A, and you have to get released. So if you have an IDIQ contract that's recurring for construction services, we're going to consider that to be 8A. You still have to come to us for release, basically. We had some stuff in this around subcontracting. There's a belief that subs aren't being notified that they're being considered by the prime contractor, so we want them to be notified. And then we give a way for you for small businesses to report if there's some kind of bad faith going on, for them to report on matters to either to the area office or the Office of Inspector General. Some of the things we clarified in this rule also involve the HUBZone program. We've made the HUBZone program a lot more like other programs. Previously, the non-manufacturer rule did not apply to HUBZones, and therefore a HUBZone generally had to supply the product of a HUBZone and could not get a waiver. Here we're saying you can get a waiver from the non-manufacturer rule for HUBZones. Okay, so that was the NDAA of 2013 final rule. It's done. Some of that applies now. If it has to do with just SBA, for example, like affiliation of joint ventures, we'll be applying that now based on the effective date. The limitations on subcontracting portion of it has to still get into the FAR, and so that you can't really use unless you do a deviation. We did a clarification also in January of last year around the information value added technology reseller footnote. Just be aware, we're treating it as a supply, and so if you use it, you have to get a waiver of the non-manufacturer rule, and the size standard for that is 150 employees, whereas the normal non-manufacturer size standard is 500. Okay. So we also finalized this summer the All Small Men or Protégé program. So this creates a program that's available to all small businesses. So we've had one since the 90s for 8A. Now we have one for all small businesses, and I think we're up to around 50 or 60 approved men or protégé agreements so far, at last counting. Some of the clarifications, obviously it has to be in writing. We clarified that the joint venture cannot be populated. Previously, we allowed the joint venture to have employees. The problem there was it was hard to determine whether the protégé was actually performing any of the work because they were not their employees, they were the employees of this other entity. Do have to be identified in SAM as a JV, and it is still approved by the Office of Business Development. Some of the changes around mentors are there. A mentor can have more than one, only one protégé at a time, but we may authorize up to 3, but they have to be in different lines of work, basically, when it can demonstrate that it's not going to be a detriment to the other protégé and they're doing different things. You have to qualify as small for the primary NAICS or a secondary NAICS if you're a protégé. Previously, a protégé had to have never had a contract or be half the size standard under the 8A program, and this now applies to 8A. They just have to be small for their primary industry. A protégé can have up to 2 mentors in its lifetime across our programs. So you can have 1 in 8A, 1 in all small, 2 in 8A, 2 in all small, but that's for the entire duration of your existence as a company. You can only have 2 under our programs. You can transfer, if you're in the 8A program and you have a mentor-protégé relationship, you can transfer that to the all small. There is a way for a mentor to own up to 40% of a protégé. We clarified that a mentor can transfer a relationship to a purchaser, And of course, the size of a joint venture can still be protested. So even though SBA has approved it, this causes a lot of issues out there. But we have a district office that may approve the joint venture agreement. But if there's a protest and it's actually not in compliance with our rules, you may be found to be other than small by our area office that does size determination. So just be aware of that. You have to follow the rules closely, and just because a district office approved it doesn't mean that you're not be able to challenge that or can't be challenged. So you want to make sure that you wait for that if there is a size protest. This is the circumstances when we'll approve a second mentor for a protege. It has to be an unrelated NAICS code, and there's a specific expertise that their current protege or mentor cannot provide. The basic relationship is a 3-year relationship with a 3-year extension. But we're going to do an annual review to make sure that the assistance that the mentor is supposed to provide is being provided, and that the protege is performing their required amount of services. We've clarified in this that the past performance and experience of JV members must be considered by the contracting officer when they're doing an evaluation, and this is kind of supported by legislation I'm going to talk about later. And then at the conclusion, we're going to get a report on how the relationship went. The rules are the same as they are for 8A. We want the protege to do 40% of the work, and it's at 40% of the aggregate at any tier. You can't have a mentor who does a lot of the work and then subcontracts to itself to do even more. It's 40% of the total has to be performed by the protege, and there will be reporting on this to the CO. And we did align the HUBZone rules again to make it easier to joint venture in that program. Previously, in a HUBZone contract, you had to joint venture with another HUBZone. Now a HUBZone can joint venture with another small business on a HUBZone contract. We have some rules, penalties if we want the mentor to provide whatever assistance they've outlined in the agreement to the protege. So if they don't, obviously we can terminate the agreement. We may prohibit a mentor from being a mentor in the future. We can always ask for a stop work order or maybe grounds for debarment. Some things to keep in mind. Now, we don't currently certify small women-owned or SDVO firms. We certify HUBZone and, of course, 8A. But your status can always be protested in connection with a procurement. So you could be a mentor-protege relationship on a SDVO set-aside. Someone can challenge your status as an SDVO as part of that procurement. We do not review joint venture agreements for all small. We continue to do it for 8A because that's what the rules say, that it has to be reviewed by SBA for an 8A contract. But for this, we are not going to be in the business of reviewing the joint venture agreement in all cases, but of course it can be protested. At that point, if you haven't written your joint venture agreement to comply with our rules, you may be found to be ineligible. And then once you qualify as other than small for your primary NAICS, you can't do any more contracting under the mentor-protege relationship. Now, there are mentor-protege programs of other agencies, and under this law and rule, they have to come to us within 1 year of August 24th, 2016, so that's August of 2017, and then we have to decide at some point after that whether these relationships are going to continue or not. This does not apply to DOD. So there's the citation to this final rule, and it's effective. It was effective in August. Okay, so next rule that we worked on, this is from the NDAA of 2014, was credit for lower tier subcontracting. And after I sent these slides over, this rule was actually finalized. So there's a final rule out there. It's an SBA rule again. So this will have to get into the FAR. And there are probably maybe system changes that are going to have to occur on ESRS and so forth. So this is kind of halfway towards implementing this. But the basic idea is if you have an individual subcontracting plan as a large business, you're going to set 2 goals. One for your goals at the first tier, and then another goal for subcontracting by your lower tier subcontractors that will have subcontracting plans. So that's how it works. Individual subcontracting plan. Right now you only goal and report at the first tier. Under this new rule, you're going to goal at the first tier and at lower tiers. And then as those lower tier subcontractors report, that will be counted towards your goals. So there shouldn't be any extra reporting by the prime or by its subcontractors. They continue to operate with their subcontracting plans as they normally would. It just will get rolled up and count towards the goal of the prime. And then, yeah, like I said, there's no limitation on the subcontracting plans that apply. They still apply even for lower tier. If you're above the thresholds, you have to have a subcontracting plan, and you have to meet your own goals. The reason we set it up that way is we didn't want the prime to set a goal and do nothing at the first tier and just rely on their lower tier subs to meet the goal. We want them to do something at the first tier, but we also want their lower tier subcontractors to count as well, because there's a belief by large primes that their goals were being set too high and that they were doing things at the first tier that they normally wouldn't do. And then the first tier subcontractors were in turn subcontracted to large businesses. So the idea is this will more align with actual business practices and still give them credit for small business subcontracting. It's only going to be counted once, so there's no threat for the agency to get double credit. There's a different report. They report differently on SSRs. That'll still be at the first tier, and so the agencies won't be getting super credit. This is just for individual subcontracting plans only, where they have this lower tier counting as well. And we've tried to clarify here as best we can that just like we allow at the prime level electronic representation of size or status, that you can also do that at the subcontracting level. We just want to make sure that you're clear that just like a prime contract, at the time of your offer, you're representing that you meet the size standard or socioeconomic status that you're claiming. So there has to be some indication, some clause saying that you represent that you meet that at the time of your offer. And we do allow you to, rely on SAM if that's what the prime contractor wants to do. And we've clarified that you can't make them go to SAM because subcontractors don't want to be in SAM. So that rule, as I said here, this is all the proposed rule. It is final, but the next step is opening up a FAR case and getting it into the FAR, and that'll take some time, but we're halfway there, I'd say. So some of this is probably old news to you, but we did enter in the Women-Owned Small Business Sole Source Authority. That's in the FAR and final. It basically is like HUBZone or SDVO, where you do market research. If you don't think you're going to get 2 offers, then you can do a sole source. If you're going to get 2 or more offers, then you have to do a set aside. So it's not like 8A where you have to go sole source. It's just like HUBZone or SDVO. Of course, the NAICS you still have to have the right NAICS. You can only do certain set-asides in certain NAICS codes where women are underrepresented, and it has to be below 4 million or 6.5 million for manufacturing. And of course, award has to be made at fair and reasonable price. So there's the citations for that. We did update the NAICS codes where you can do set-asides. It was effective March 3rd. Here's the site to the Federal Register. It's also available on our website. So there's around 445 6-digit NAICS that allow set-asides or sole source authority. Certification, this was also part of Section 825 of the NDAA of 2015. So we did an advance notice of proposed rulemaking and got comments. We're drafting a proposed rule to implement a certification program for the Women-Owned Small Business Program. Until we issue a final rule saying that you have to be certified, we're operating under the old rule that allows you to self-certify and then upload documents basically to a repository. There's some people that are trying to claim that you have to be certified by a third-party certifier. We don't think that's correct. Those entities charge, and we don't think that right now that we should require everyone to go out and pay money to be certified. So we're going to operate under the old rules until such time as we come up with the final rule. So that was the NDAA of 2015. The NDAA of 2016 had some interesting provisions. One, as I already mentioned, we want the contracting officer to consider the past performance of all team members, including joint ventures, when they're evaluating. We had situations where the CO or the solicitation would be written such that they would only consider the past performance of the joint venture itself, not the members of the joint venture that were actually going to be doing the work. And that was very disadvantageous to small businesses, especially when they came together as joint ventures for the first time. If they have past performance, we think you should consider that because they're the ones who are actually going to be performing. Section 868 changed the scorecard, and so the way we rate agencies, every year we give an agency a grade and the government a grade. Up until recently, the 80% of that was made up of your prime performance, 10% was subcontracting, and then 10% was a peer review of how the agency basically was doing in terms of small business contracting. Now the maximum for prime contracting is going to be 50%, so that lowers it from 80 to 50%. And the rest of the 50% is going to be made up of subcontracting, and then something they identified as a comparison of the number of awards to small business concerns in one fiscal year to a prior fiscal year. And they also wanted us to do that for subcontracting. So we've come up with a scorecard that'll be in effect for this fiscal year we're in right now. And 20% of it will be subcontracting, so that goes up from 10% to 20%. And then 20% is the peer review, and then 10% is going to be this comparison of the number of small businesses awarded contracts this fiscal year to the prior fiscal year. We have a whole, calculation on how we're going to do that. We did not know how to do comparisons of subcontracts because we don't get NAICS codes for those, and so we're not going to do that this fiscal year. Also, under this National Defense Authorization Act of 2016, they basically authorized firms to challenge SBA's size standards. Every year, every 5 years, we have to review all the size standards and then propose, either that they go up, that they stay the same, or that they go down. We just completed our most recent, the first 5-year comprehensive review, and we're about to start it again. But under this, instead of going to court, if you don't like our size standard, small businesses will be able to go to our Office of Hearings and Appeals. There's some clarification in this NDAA about when an OSDB receives notice that a solicitation unduly restricts competition, certain things they need to do. There's an extension of the idea around we want SES in their performance plans. We want them to be responsible for meeting the small business goals, not just contracting folks, but program people too, the people with the money. So this says that they're also responsible for the agency's subcontracting goals. So there's been some implementation around FAR changes on subcontracting. This goes back to the Jobs Act of 2010 and SBA's rules on implementing that we did probably in 2011 and 2012. They're just now getting into the FAR. This is a proposed rule, and there's some final rules that are coming up. And basically the idea is that if you're paying your subcontractors 90 days late, that there's and it's unjust or untimely, that there's a way for us to consider that in evaluating the large prime contractors' past performance, basically as you rate them. And so this just implements what we've done in what we did based on the Jobs Act of 2010. And there was also, out of that same rule, there was another FAR rule on when you use a small business subcontractor to help you prepare the solicitation, but you don't use them in performance. And again, the idea is that if that happens, the large business prime, we will consider that in evaluating how the large business prime performed on that contract. We will consider whether they used the subcontractors in performance. And it also clarifies that the statute says that you do goaling in terms of percentage of dollars subcontracted, but agencies have been setting goals based on total contract dollars, and this says you can also establish goals based on total contract dollars, because obviously if you only do a little bit of subcontracting but 100% of it goes to small business, you'll have 100% subcontracting, but that won't be a lot of dollars, whereas if you set it in dollars, that's a lot more meaningful. And so agencies have been doing that. So what we're saying here, and what the FAR is saying now, is that you can do that. And this was effective November 1st. We do want to make sure that when someone goes from, for example, on a long-term contract, they go from small to large. At that point, you can request a subcontracting plan. Also, if you have a contract and it doesn't meet the threshold for a subcontracting plan, but then it gets modified to go above the threshold, that a subcontracting plan at that point will be required. And then this makes clear, which has always been in our regs, that the prime assigns NAICS codes and size standards to subcontracts, and it's not just whatever's on the prime contract. It's actually the NAICS code that describes the principal purpose of the actual subcontract, and from that you will get the size standard. Obviously, when you have these kind of things, you can't have the prime contractors write into the subcontract that you can't discuss things with the contracting officer, because otherwise there's no way for the contracting officer to know that the prime is paying subs late or not using them in performance. So this says you cannot prohibit them from talking about that with the contracting officer. And there's other stuff around reporting and so forth. There is going to be under this, what we did in our rule was we want to allow agencies to get credit, subcontracting credit for orders under other agencies' contracts. Right now, when HHS orders, let's say, off the GSA schedule, they get prime contracting credit, but they don't get the subcontracting credit right now. Under this new policy, effective November of this year, there will be a way to get subcontracting credit for those orders. And we also clarified that we do subcontracting plans for the contract. Okay, so we don't do them for orders, but you can establish subcontracting goals for particular orders. Okay, so some of the other things that we've accomplished over the last few years, this is out of the NDAA of 2016, is a direct final rule that authorizes firms that are located in base closure areas or closure areas near them, because right now base closure areas qualify, but the area around the base does not qualify as a hub zone, and that's usually where the economic activity is most harmed, is around the base. So this extends it to areas that are connected to the base. It allows firms in qualified disaster areas to qualify as hub zones if they were previously a hub zone area. And Native Hawaiian organizations can now own HUBZone concerns. And this was in the, this is a direct final rule that was effective in October, and it implements part of NDAA of 2016. So NDAA of 2017, a lot of things in this that just came out, was just signed in December. It extends the comprehensive subcontracting plan until December of 2027. That mainly affects DoD. It requires GSA to issue a report on small business goaling performance, but without any exclusions. Right now, when we set goals and we report on how agencies like HHS do in their performance, we exclude certain contracts, like things like FPI, Federal Prison Industries, or JWAD contracts that are mandatory sources. We don't include those when we're calculating how you did as a percentage. And we're going to continue to do that when we report, but this requires GSA to do a separate report without any exclusions. And then we had done something around including overseas contracts in the base, because previously anything performed outside the U.S. was not included in the base. So last fiscal year we included them in the base based on the NDAA of 2013. Well, DoD was not happy about that, and so basically they got excluded again things performed outside the United States if they have to do with foreign military sales, humanitarian, contingency, and so forth. There was a situation where an agency had some issues around using the credit card to do acquisitions above the micro-purchase threshold of $3,500, and so now all OSDBUs are responsible for reviewing credit card acquisitions, and so that's a new duty for the OSDBUs. Also, this is new not just for OSDBUs, but for mentors, for SBA, for PCRs, and so forth. We have to provide small businesses with avenues to get resources on compliance with federal regulations. There was obviously a concern in Congress that it was difficult for small businesses to comply with all the rules and that there wasn't enough resources. So we're going to have to come up with a way to direct people to the best resources on compliance with regulations. And then we have to provide DAU, FAI, SBDCs, and PTACs with a list of all the changes that I'm going over right now that have been happening. The NDA clarifies that failing to file a subcontracting report may be considered a material breach and may be considered in past performance evaluation of the prime contractor. The OSDBU is now responsible for reviewing subcontracting plans, and we have to issue examples of good faith compliance with subcontracting plan performance. A new thing that we're going to have to work on allows a subcontractor to get past performance for performing a subcontract, and that it has to go into the CPAR system. If a subcontractor has never had a prime contract and never got a rating in CPARs, and they're a first-tier subcontractor, and there's a subcontracting plan in place, they can apply. They come up with a pros rating, they submit it to the OSDBU and the prime contractor, and then based on what the OSDBU and the prime come up with, it may be entered, or there may be a way to not enter it, and there'll be a rebuttal. And again, this is supposed to go into CPARs so that the small business subcontractor can have past performance in that system, even though they don't have a prime contract or haven't had a prime contract. This pilot program that they created will last up to 3 years from the time we actually implement this, and there's a small business that gets a rating. GAO is going to do a review of this and report on how it's going. And the application that we talked about, it can go to the CMR, other SBA employee, or OSDBU. So there's going to be involvement of SBA, the OSDBU, and the prime contractor in getting this pilot program created. Some clarification around what DoD does in connection with their Mentor Protégé program. It allows us to create size standards for agricultural enterprises. And then a big change is that the VA will no longer be using their own definition for their program. The VA has their own statutory authority to do set-asides for veteran-owned businesses. We're going to have the same definition, so we're going to work with them to issue joint rules. And then if you're found to be ineligible, you'll be able to appeal to our Office of Hearings and Appeals at SBA if you're applying to the VA. Petitions for reconsideration, they're clarifying that this will be filed within 30 days of us issuing a final rule. So that size standard issue that I've mentioned will be coming up once we issue a final rule. Now, the SBIR and STTR were extended till 2022, and there's going to be a report on DoD major defense acquisition. Department of Energy right now is allowed to count subcontracts toward their prime contract goals under their M&O contracts. There was a proposal to allow major defense acquisitions to be able to do that as well. But instead of doing that, luckily, they're now just going to do a report. And so we'll see how that goes. And then GAO is going to do a study on DoD contracts awarded to minority-owned and women-owned businesses. So I believe that I have gone through my slides. I have my contact information here. And I think we're going to do questions, because that's usually the best part of conducting this. And let me see if, do I need to help you get to this?
Yeah, let's see if we can get back. See if we can get back to it. Yeah. So, as always, this was extremely helpful. Let me just thank you. So, while we're waiting for questions, let me ask a couple that I had. As you can see, I have some my pink notes here.
You got a lot of pink notes.
Actually, I do. I always do. Well, I always find your training to be fascinating and exciting for me. So I'm always paying attention, trying to get all of the nuggets while I have your pieces of your demanding schedule. So regarding the lower tier subcontracting rules, do you know when those are going to be finalized?
No, it's kind of like the limitations on subcontracting rule, all these other rules. We can open up FAR cases, and obviously a lot goes into that. There's going to be a transition, so we're going to have to deal with that starting out on getting rules out. Sure. And then, how it works is a small business committee gets together and they draft what they want the FAR to say, but then we send it up to various channels, up to the FAR council and so forth. They come back with comments. So there's a lot of back and forth, just in getting these things written. A lot of agencies come together, DoD, GSA, and SBA, and others, write the rule. So there's still that back and forth, and then they still have to do a proposed rule and a final rule and get comments. So
Okay.
there's almost always there's 4 steps: SBA proposed rule, SBA final rule, FAR proposed rule, FAR final rule. That's generally how we
okay.
actually implement legislation.
Okay. Because a lot of times small businesses and even contracting officers feel that if it's not in the FAR, it doesn't apply. And so maybe if you can shine some light on that, because we do have some progressive contracting officers that are willing to implement the law as it's written, even though it's not in the FAR. But
Yeah, I think most contracting officers are going to be more risk averse, and they're going to go what the FAR says. And if the FAR hasn't changed, they're not going to follow it.
Right.
We do have the deviation process, where you can do a deviation as a CO or an agency to change something. I mean, that's the proper way to do it. The reality is, though, is that if a CO puts something in their solicitation, we're following this law, and no one challenges that, and offers are submitted, you can't challenge that later because you submitted an offer. When something's apparent on the face of the solicitation, you have to challenge that up front before offers are due. Once those offers are due, then everybody's going to play by those rules, basically, is how that usually works.
So how can a contractor win if or I guess on the antithesis of this, how can a contracting officer lose when they say, well, look, it's in the law, even though it's not in the FAR? Can they, that should stand on its face, right?
I would think so. I mean, again, we usually wanted people to follow the FAR and wait till the FAR is done. But the reality is, if you've told everyone up front what the rules are, they're accepting that by submitting an offer. That's how it usually works.
Okay, fantastic. So here's a question. How are funding agencies' orders against GSA, multiple award schedule contracts, BPAs, GSA orders, GWACs included in the base for subcontracting goal achievements?
Yeah, that's a pretty detailed question that I probably shouldn't try to answer off the top of my head. But I think the general idea is just like prime contracting, we want subcontracting to be treated the same way. So when you do an order, if HHS orders, they get small business credit. If there's subcontracting going on under that order, obviously we have until November to figure out how to do this, but the idea is that you will get the credit. Right now it's all going to GSA. If there's an order that you place with a large business and there's subcontracting going on, you'll be able to get credit hopefully in November of 2017.
So is it 1 November or is it 30 November, 1 December? What's after November?
I don't know what the exact date is. I think it's November 30th and November 1.
Only because I'm so surprised. I thought that the agency already got that subcontracting credit. So then when you do the scorecard, GSA should be weighted heavier than everybody else since they're getting credit for the entire federal government. The rest of us are suffering, Ken.
You set your goals based on performance. So. Yeah.
This is so unfair. GSA, if you're on the line. All right, so here's another question. In regards to goaling, how is the eligible dollar pool determined by SBA when looking at subcontracting achievements? Is it established based on A, the total of expended acquisition dollars? B, I feel like this is a word problem, math word problem.
Yeah.
B, total expended dollars on actions that are selected in FPDS as requiring a subcontracting plan, or C, another method?
Again, I'd have to get more specific answers for you because that's a very detailed question, but I think we do it based on, we pull the data from your SSRs that are reported, and we report it as a percentage, so your goals are based on a percentage of subcontracted dollars, just like subcontracting plans are reported.
Yes.
So that's how your grade is calculated.
Yeah, I think, the SSRs is, to me, one of the most complicated aspects of the subcontracting program, especially when you have individual SSRs based on a summation of all individual plans by that contractor versus a summary SSR for, an SSR for a commercial plan, which that company has awarded, has been awarded contracts by different federal agencies, and then some put the percentage, some actually will put 100% of their award of their subcontracting to that particular agency, when actually they've done some commercial work, which is why it's a commercial plan. Mm-hmm. So to me, that really, and I'll just ask you on behalf of the small business community who's trying to support this, we really need SBA to take a look at that whole, if there's a way that SBA could make it easier to understand and apply. Because when we do our data dive and looking at our subcontracting and the reports especially, we're finding such a great disparity between those contracts that should receive reports and those that are actually doing it, because some are just confused, and I can tell you a lot of our contracting officers
a lot of that's controlled by contracting officers for each plan, so sometimes they don't accept it, or they accept it when they shouldn't.
Yeah.
As we implement lower tier subcontracting, as we implement credit, we have this requirement to compare subcontracts from one fiscal year to another.
Yeah.
Maybe we'll be able to improve the system. But again, that's subject to funding and everything else.
I understand.
But it's not going to be overnight, but we are trying to work towards that.
Okay, that'll be a big help. So here's a question. I'm aware that after 30 November 2017, contractors will need to provide assurances that they will include subcontracting data for each order when reporting subcontracting achievements. So this is similar to the question you just answered. For IDIQ contracts intended for use by multiple, but how are they reporting it now? How are funding agencies placing GSA orders currently receiving credit?
Right, and I think my understanding is the plan is set up for the contract, the IDIQ contract that GSA sets up. GSA is the contracting officer, so they monitor the plan. Right now,
they're supposed to monitor the plan.
That's their responsibility of the CO. Right now, any credit for subcontracting under those kind of contracts is going to the contracting agency itself, the one administering the contract. We made the policy change in our rule back in 2011 to say orders should go to the funding agency just like they do at the prime level. However, as you can see, it takes a long time to get our rule into the FAR, and so we're now in 2017. It's now in the FAR.
Yeah.
We still have to change the system, and that won't be until November.
So Ken, just to make sure that I'm clear, so when you say the funding agency, you're not just talking about the department, you're talking about that individual funding office that now has an AAC code, right?
Well, I'm talking about when you enter something in FPDS, it's from HHS, it says HHS.
Right.
That's how we count it. So we'll go to HHS. The way you distribute it, that's up to you once inside HHS. But for us, you'll be getting the credit as HHS.
Okay, and I think probably for the individual who wrote that, the confusion again is that we thought we were already getting credit. And so the credit then that we're getting in ESRS right now is just for those contracts that we award ourselves. Mm-hmm. So then what's the commercial plan? Why do you have an SSR for a commercial plan for a contractor who has a commercial plan and we've ordered on the schedule? But they're submitting reports and they're including HHS in their report.
Mm-hmm. Yeah, I'd have to look into the specific commercial plan.
Okay.
How that works. Maybe you were getting credit, but my understanding is for subcontracting you were not.
Some were not. Okay. Mm-hmm. See, again, confusing.
Mm-hmm. I agree.
All right. So here's a long question about the Buy American Act. It says it's a policy loopholes question. An SBA supported biotech buys lots of disposable supplies from a vendor catalog, gloves, pipettes, etc. If the vendor is foreign, then there are necessary approvals or waivers that Fed grants staff must perform. So I guess they're saying grants individuals who are at the federal level and they work in grants.
Yeah.
Fed grant staff must perform But if those same supplies are purchased through a U.S. distributor, a reseller at slight markup, then no approval or waiver is needed. So are they talking about a difference between how it's handled under a grant versus a contract?
Yeah, they are, and I
Okay.
have no knowledge of how grants are operated. I know that if it's a small business set aside contract, that you'd have to supply the product at least 50% of a small business or get a waiver of the non-manufacturer rule
Yeah.
under those procedures we talked about. Grants, you may be right. Maybe the Buy American Act doesn't apply to grants, and if that's the case, that's something that maybe they should look at.
Yeah, and I'm not familiar with the grants rulemaking process. Oh, grant rules either. So
Yeah.
okay.
Um,
But if you want to write an email to
Maybe we should refresh and see if there's any other ones. Have you done that?
I haven't, but I'm going to. I was going to ask that.
Oh, okay.
Answer this last question.
Okay.
So will this if not, I have plenty of questions for you.
All right.
So
All right.
will this presentation be archived, or will the slides themselves be available? The answer is yes. The presentation will be made available on FAI.gov, and the slides, once you complete your survey, then you can get the PowerPoint slides also. Okay, so here are a few more questions. There seems to be a void in the knowledge of women-owned small business vendors on the use of the SBA repository for their financial documents and how a CO is supposed to access this information.
Yeah, the whole women-owned system that was set up is kind of unique in that the way it was originally written, you were supposed to submit these documents to the CO themselves. We thought that made no sense because the CO doesn't make ownership and control determinations. That's not
right.
their job.
That's correct.
So that's why we created this repository. You know, we've put it in the regs. We've tried to provide as much training as possible. The bottom line is, you know, we have a protest process. So if someone thinks a women-owned small business is not eligible, they can protest that just like any other small business thing. The CEO is really not going to do a lot of monitoring of eligibility, and they shouldn't. It's not their job.
Yeah. No, I mean,
and we don't want them to, frankly. I mean, only SBA
Right.
can make size determinations
Exactly.
or HUBZone determinations.
Sure. And contracting officers don't have time.
Right.
You know, in all honesty, you know, I've been there. They're just trying to get these contracts awarded, Ken, and they're not trying to have to now evaluate financial documents, someone's balance sheet to determine if they qualify for a set-aside, especially when I can just award it to a women-owned small business and still get credit.
Yeah, and we
as a vendor.
Right, and we did set up certified.gov, so you can check that for the women-owned small business. It is easier and better than the old repository.
Oh, okay.
And we're going to be doing HUBZone and 8A applications on that, and eventually women-owned certification on that.
And it's certified.gov.
Yeah.
Okay, very good. So currently primes review their subs ISR reports and include it in their reporting. How will this work with the lower tier subcontracting rule?
Yeah, I think they're still going to be responsible for everything that they're responsible for now. But the difference is that right now, for their reporting on how they're doing under their subcontracting plan, it should only be the first tier that they're reporting on. Mm-hmm. Once we set this up where it will flow up, they'll have two goals, first tier and lower tier, and what their lower tier subs do will count towards that lower tier goal, basically. That's all. It's really minimal. It just allows primes to not necessarily have to do everything at the first tier level is the intent.
So we've invited Angela Terry to come out and to give us some training on subcontracting reporting.
She'll be able to answer all these questions that I cannot answer.
Yeah, so that'd be a good time. And that's scheduled for April, the second Thursday in April. So I know that's a long time for you guys to get your questions answered, but most certainly you can send the questions to your respective OSTBUs and they can assist you with getting additional questions regarding the subcontracting program until we bring Angela on board. And here at HHS, we've hired a new subcontracting program manager, and his name is Wallace Sermons, and you can send Wallace an email at wallace.sermons@hhs.gov. So, another question. Currently, the CPAR has a tab for small business, and that is where I put my evaluation. What it does not allow for is the subnames individually. So I just named them per bullet with verbiage.
Yeah, and I think what's going to happen though is that when we get this pilot program set up, which again could take a year or more, if you don't have a past performance rating as a small business, you can get one for your subcontracting, which is not allowed. It'll appear just like you'd done a prime contract, basically, is the idea.
Well, in FSRS, the primes are supposed to list their subs there by name. So
But this is a past performance evaluation that you can use when you're going after a prime contract. So that's what
Okay.
happens is you go for the prime contract, you have nothing.
Yeah.
And you're supposed to get a neutral rating, which
Okay.
is, supposed to be neither good nor bad, but what happens is you often lose out to people with good past performance.
Yeah,
So now you
right.
can start using it.
Okay. Well, that's really good, because I mean, I'm one who contends that the largest playing field for small business is at the subcontracting level. So it's good that they'll have that. I actually like the part about the teams being able to use the team's individual individual past performance, and I think that's good. I think some contracting officers are doing that already, but it's good to see that SBA is recognizing that and putting that out there. So
Yeah,
that's
some
extremely
are, but what
helpful.
happens is some were not, and then they were just disqualifying these joint ventures even though they had a lot of past performance.
Yeah,
experience.
exactly. Okay, so here's a question. Can you clarify what types of changes are effective simply through a final SBA rule as opposed to what needs to wait for a FAR rule?
Yeah, and the best way I can explain that is when it has to do with SBA and what SBA does, those are effective as soon as that effective date, that 30 days, passes. And so the best example of that would be like 8A application rules. Only we make 8A determinations. So when our rule is final, it's final. Same with like affiliation rules. We're the ones who do size determination. So when it's effective in our rule, then it's effective. When it's something like limitations on subcontracting that has to get into the FAR and then actually get into the clauses that go in your contract,
Yes.
that's when our rules are not necessarily effective right away. Same with this subcontracting plan stuff. The FAR, I'm looking at how we got to modify the FAR. It's going to be a
Sure.
lot of work to change the FAR to incorporate this.
Yeah.
Until that's done, you're still stuck with the old FAR, basically.
Well, even with that, there are certain areas or subject areas that are more complicated than others, and it also requires some socializing of those new requirements. And that's just my way of inviting you back to
And
HHS
that's
to
what
do
I'm
the
trying
training.
to do here.
So,
Just giving you a heads up of what's coming.
Yes. So Ken, in the NDAA of 2016, we mentioned in Section 870 that OSDBU is responsible for receiving notices when a small business concerned that feels that a solicitation is unduly restrictive and restricts the ability for that small business concern to compete. And I know that we get a lot of questions in the OSDBU office about, well, what gives OSDBU the authority to even review a requirement, to even make the recommendation to set aside. So can you talk about that at all?
Yeah, I mean, there must have been someone, at least enough on Capitol Hill to get Congress to put this into one of the list of many things that OSDBUs have to do. There were a lot of changes in these past two NDAAs. And I think the idea is just like a PCR, they intend for the OSDBU to advocate for changing solicitations if they think that they can make a good case on why it unduly restricts competition, basically.
Yeah.
So it's more of an advocacy role.
So the part about OSDBU reviewing subcontracting plans, we were always under the impression that we were responsible for reviewing the subcontracting plan of the apparent successful offer. Are we saying now, under 2017, that we should review all subcontracting plans that come in?
I mean, if you read it broadly, I think that's what it intends. I think the idea is that your organization should have oversight over that. So obviously, it depends on how many people you have and how many there are to review.
Okay.
I mean, you may have to take the top ones or the most valuable ones or do a sampling. Depends on how you want to do it. But if you read it strictly, it's one of your additional duties.
Yes, I see. All right, so let me see if there are any. There are no additional questions.
Good.
Yep. So the training materials and slides and videos will be made available shortly after the conclusion of the training. And let me see if there's anything else. Okay, so I don't have any other questions. I think we got quite a bit in today.
That was
And
an hour's worth of material. We did it quickly.
It was,
Good.
but it's because you're a fantastic teacher too.
Good.
So, is there any closing remarks that you want to share with anybody as far as the rules going forward? I mean, while we're already through the first quarter of FY17, well, actually, we're in now the second quarter. I'm sure that SBA is working on new legislative recommendations. So soon we'll have some new changes coming out for 2018. So is there anything that you want to share to the contracting office community?
Yeah, I've kind of given you the update on where we are. There are several FAR cases open, including limitation on subcontracting. We're going to hope to get those out as soon as possible.
Fantastic.
And then coming up in the new year, there's going to be the women-owned certification program, which will be a big deal, proposed rule, and then maybe a HUBZone proposed rule, and then some other ones as we implement NDAA 2017, including the past performance.
Well, we hope you guys have something in there that can increase the number of HUBZone firms, because, you know, HHS, along with several other agencies, are just having a hard time finding HUBZone firms that can help us meet our mission. So it'll be great if we can get more HUBZone firms in. Let me just thank you on behalf of HHS, but not only HHS, the entire small business community. It's always a pleasure to have you here, and we're glad you're on our team. So thank you, Ken.
I enjoyed it. Thank you very much.
All right. Thank you, everybody. Don't forget to complete the survey so that you can get your certificate and your CLPs. All right. Second Thursday of every month. Have a great day, everyone. Thank you.